Welcome, everybody. Oh, my closed captions are not cooperating this time. Okay, well, I'll work on that later, see if I can get those up and running. But in the meantime, welcome. My name is Christy Baglow. I'm the Director of Statewide Training at Florida Legal Services. And I am thrilled to welcome all of you today. I'm definitely going to give you some extra time to log in because we had a ton of interest in this topic. So I'm so glad that Florida's Children First and Robin and Melissa and Travis are helping everyone learn about this topic today. I'm excited to learn about it, and I see that hundreds of you are also excited to learn about it. So welcome, everyone. We're going to be learning about master trusts, able accounts, and special needs trusts today. And we have with us Robin Rosenberg. I'm sure you all know she's the Deputy Director of Florida's Children First. And she is also an active member of the Public Interest Law section. Oops, I'm cutting off her bio here. She received her BS in Communication from Northwestern University and her JD with high honors from the University of Florida. Go Gators. She's fabulous. You all know. I just wish I could download her brain every time I hear from her. Next up, we have Melissa Barnhardt. Melissa currently works at Comerica Bank as a special needs solutions specialist. Prior to that, she worked in a similar position at Wells Fargo for 11 years. Melissa has been working with families that have loved ones living with diverse abilities for the last 30 years. She has a JD from the University of Illinois, which was previously known as the John Marshall Law School, and an LLM from DePaul Law School. So welcome, Melissa. And last but not least, we have Travis Finchum. Travis is a double Gator, so I have to mention that, with his bachelor's in law degree from the University of Florida. He's a board certified elder law specialist by the Florida Bar. He's the managing partner for the law firm Special Needs Lawyers, PA. He's a past chair of the Special Needs Trust Committee of the Florida Bar's Elder Law section. He has also served as the chair on the Elder Law Board Certification Committee. He is a member of the National Academy of Elder Law Attorneys and the Academy of Florida Elder Law Attorneys. He is a liaison between the Elder Law section and the Real Property, Probate, and Trust Law section of the Florida Bar and is on the executive council of both sections. So welcome to all of you. The recording and PowerPoints will be sent out tomorrow, and the CLE credit and certificate of attendance, I promise, will be there in that email tomorrow also. So without further ado, I will pass this over to Robin.
Helps if I unmute. Good afternoon, everybody. Thanks for joining us for this important CLE training. We are excited to talk to you about kids' money and how you can protect, how you can acquire it for them and protect it for them so they have it to use when they need it. So Florida's Children First has been interested in these issues really since we started back in 2012, because a key focus of our organization is promoting the rights of children and youth. And of course, listening to them directly through Florida Youth Shine, our ancillary, well, we're kind of the parents to the statewide advocacy organization of current and former foster youth. And they talk to us about their problems and their concerns. And of course, their financial well-being is really critical. So we're excited to bring colleagues in today to share 3 different topics with you that are all related to each other. So my section is master trust. As I go through, I will take pauses, and if you put your questions into chat, Christy Baglow will feed me questions at pause time, but feel free to either put them in the chat or the Q&A, and we will try to answer them as we go through. I'm going to take them during my presentation. Other presenters may wait till the end, and then we'll have additional time at the end. So, and as Christy told you, we will be providing you with the slides, and in the slides are will be live links to all the materials that we're at least for a couple of us that we're referencing, so you can have the actual materials. So today we are talking about master trust, and I don't know if you all saw the news over in the spring of 2020, national news, National Public Radio, the Marshall Project did a large national story about child welfare agencies getting money for children that they were entitled to through Social Security primarily, and keeping it themselves. And in some states, not even telling children that they were applying for SSI on their behalf, and then taking and keeping their money. And it was national news, and they featured young people who aged out of care and were homeless and should have had access to money that had been paid to the state on their behalf. And so when these stories came out, I was kind of like happy to say, yay for Florida. This is an area where really we can applaud the state, because we're not in the same posture as all of those other states that they were featuring in the news story. Florida actually has good law on master trust and what we do with children's money. So can it be better? Yeah, law can always be better. Can the practice be better? Yes, the practice can always be better. But let's see what Florida has and focus on the positive. So what we're going to talk about today are the requirements imposed on DCF, which are in turn imposed on the community-based care lead agencies that serve children. So these are the items that we're going to go through today about the state's role with regard to master trust. So the first item is the responsibility to apply for benefits. You'll see that it's in the administrative code provision for comprehensive placement assessment. That's at the beginning. When the kid first comes into care, their caseworker, you may call it child advocate in Broward, call it case manager, whatever you call it, has a responsibility to ensure an application is made for benefits. This is not always done. Now, the caseworker themselves don't have to be the people that apply for the benefits. They have to make sure it happens. Often within the agency, there might be a unit called revenue maximization, and it's staff and revenue maximization that does this process. But the responsibility to identify and to initiate is on the caseworker. So what are your tips? Don't wait for the caseworker to figure out whether or not the child is entitled to benefits. It is not the top of their priority list. And in lots of parts of the state, that way too many cases and they're overworked. And so they need to make sure that children are in safe places and having their current basic needs met. So getting money to come in under their name is not a top priority. So if you're involved in a case, whether you're an attorney for a child or a guardian ad litem, or however you're involved in a system, be on the lookout for, does this child potentially have an entitlement to benefits? And the things you can ask about is, do they have a parent who is either dead or disabled? If that is the case, and that parent worked and paid into Social Security, there may be a benefit available to the child, regardless of the child's own personal disability. So death, retirement, disability benefit. And that is also the case if the child came into care after living with a grandparent. So grandma was raising them and then grandma died and the kids came into care, there can be that benefit available. It's not very usual, but there are military, railroad, and Black lung benefits that can be payable to children if parents worked in those fields. And then finally, does the child themselves have a disability? And this would possibly make them eligible for supplemental security income. And I've just given you the basics of the childhood disability definition. It's not a whole training about getting SSI, but this is what they're looking for children to determine whether the child might have a disability that SSI would be eligible, that would make them eligible for SSI. And one thing that I didn't put in here is it's important for the child and for the child to accumulate the assets, but it also is really important if children are on a path to reunification. And we know one of the major barriers that parents have when they're struggling with their children is income security. So if they're struggling to pay rent and buy food, having a source of income for the children in their home can really make that reunification possibly faster and more likely to be successful. So yes, the child's needs and care are supposed to be met by the child welfare system, but most of them, over half, will go home, and that money would go with them to help their family take care of them. So it's really for both purposes. So I'll pause here and see, Christy, if there are any initial questions about the responsibility to apply for the benefit.
Yes, we did have one question come in. Does the child need to be legally adopted by a grandmother to receive the benefits from her?
Good question, and the answer is no. There are lots of grandparents that are raising grandchildren, and a formal adoption is not required for the benefit to accrue. So it's a great question. I'm not expert on what it is actually required, but I know adoption is not required. So awesome question.
That's the important thing to know. That's the only one I see so far.
Okay. So the second thing is they got to go out and get this money, and the Florida law and the operating procedures tell them that they have to take the money and put it in Florida's master trust account. And so the operating procedure that I've cited tells DCF that they are to, when they get the benefit for the young person, to have themselves be made the representative payee for those funds. And I've noted here that that actually contradicts the Social Security's order of priority of who should be a representative payee. And if you click on that link, it'll show you what their order of preference is. But DCF, routinely what they will do is they'll apply for the funds, they will make themselves the representative payee. Without getting into all the details of how the account works, it is basically one large bank account with sub-accounts. So they're not opening a new account for that child, they're putting the money in and they're keeping tabs on it with their accounting system. Several years ago, DCF turned over the responsibility for managing master trust to the community-based care lead agencies. So they kind of wiped their hands of the work, but that accounting function is now with the lead agency. I've given you the citations for the law that enables them to make those claims, to run the trust, and the operating procedures. It's very exciting reading. Not. Okay, so the advocacy tip here is to think about, should there be an alternative representative payee? You know, it may be that there is someone else in the child's life who's a higher priority, who could serve as the representative payee while the child is in care. And you can advocate for that, certainly with the Social Security, their regulations they call POMS, P-O-M-S. But just make the note that even if you find someone else to be the representative payee, so long as the child is in state care, either in out-of-home care under DCF, and DCF is paying for that care, they can still collect the cost of care, which we're going to talk about. So it may or may not be helpful to have someone else determined to be the representative payee during the time the child is in care. Any quick questions there?
Yes, we did have one come in. Does it apply? And I'm not sure which thing they're applying to, but does it apply for caregivers who have PG, which I think is permanent guardianship?
So when a caregiver has permanent guardianship, the representative payee should be switched to that caregiver. So technically that child welfare case is closed, and we'll talk about what happens when the case is closed toward the end. But the DCF will not keep a master trust account open for a child who is not in an open case. So PG themselves should have be the representative payee.
All right, that's it.
So big chunk of thing, and this is really where the national controversy and discussion was about, is that the state pays itself back for cost of care. So if they say the parent had a good job and they get $1,000 a month for a death benefit, and the state is paying a foster parent $550 a month, they can take that cost of care and pay the state back. And the statute that provides the authority for that, and actually the requirements for that, are listed on this slide. And the cost of care for this purpose is the cost of residential services. Actually, the law says that DCF is supposed to charge all of the clients for the services that it provides to them. It's not limited to foster care. It's, if the person can pay for the service or has a third party benefit that would pay for the service, they're supposed to collect it. The biggest chunk is going to come through foster care. So this is it's required in the statute. Some people argue that it's not fair. Why should children have to pay for their own cost of care? And that's a very compelling argument. There are a couple of parts of that. One is that Social Security money and benefit is intended for the daily needs of the child. So that's the purpose of the federal government giving that money. And so it's just a different pot of money to cover for the care. And another is that for many of the children, if the money accrues, they could lose other government benefits. So, and we'll talk about that. We'll talk about that in a minute. But just to be clear, just because they can recover the cost of care from those benefits does not mean that they will take the children's wages for paying for that cost of care. And the children are not liable for paying for the cost of care. It's the third-party benefit money that they can take. So, so it's important. It's not, and apparently in some places other states have taken children's wages. That is not prohibited in Florida. That's not the purpose of getting the reimbursement for cost of care. If the cost of care is more than the benefit amount, they have to leave some money in the child's account. So what the federal government calls a personal allowance, and the minimum under the regulations in Florida is $15 a month. So that has to accrue in the child's account. Some children may get a retirement benefit of $300 a month and their cost of care is over $500. They can't take all $300, they have to leave the $15. And also important to note, while the community-based care agencies have the responsibility, they don't get to keep the money. The money goes to the state of Florida. So they have the work, but they don't get the benefit. One of the reasons, and you'll see in statute that I've cited here, one of the reasons for taking that cost of care is to keep the client from losing asset-based benefits. So this applies to our kids that get SSI and our kids who are receiving APD services, such as APD group homes, because the APD is a Medicaid benefit, and both SSI and Medicaid have asset limitations. Those kids cannot have more than $2,000 in their account, or they will lose those federal benefits. The flip side is young people who are getting death or retirement or disability benefits on their parents' work record do not have an asset limitation. And this graph pie chart shows you the yellow is the amount of money received for SSI. So most of the money coming into trust is in SSI. So the rules are really geared toward making sure they don't go over asset limitation for kids with SSI. And sometimes that sweeps up other children. So it's really important to check the accounting, which should be provided to the child. It can be provided at any time upon request, and it must be included in judicial reviews. Look at it carefully. Look at the timeframes. What was the child charged for? Sometimes, if they were incarcerated for the month and yet the group home cost was deducted, that's an error. Was the amount charged correct? If they were in a group home in September, but a foster home in October, make sure that they're pulling the amount for the foster home in October, not just carrying over the group home amount. And also make sure that no other entity was responsible for paying. They should not be deducting cost of care for kids who are in APD group homes when Medicaid is paying for that group home. And I'm going to keep going because, I guess I'll stop here real quickly. Are there any questions now, Christy?
We had a flurry of them, so let me try and narrow it down.
Okay.
What if a child is on the med waiver and in an APD group home? Can the cost of care still come from the master trust?
No, that's exactly what I'm talking about. It cannot. Mm-hmm.
All right. How often is DCF or the agency required to submit trust info to the court?
every 6 months attached to the judicial review, but it can be requested at any time.
All right. If a child dies while in care, who gets the money accrued in the account?
That's a good question. I think what would happen is that any money paid by Social Security would be refunded to the Social Security Administration. And if there was any claim on it, then application would be made to the Social Security Administration. As far as I don't recall whether the rule addresses that at all. And I've never had to work with anybody where that occurred, so I don't know.
All right, we'll save the other few for later.
Okay. Next point. The requirement is overall to be protective of the child. And so the statute tells them that how they spend the money, including taking it for cost of care, has to keep in mind both the short-term and the long-term needs of the child. So paying back cost of care is considered a short-term need. But the statute has this great language in it that I've put up on the screen that is telling the state, hey, look, as people turn 18, they need more money. Or if kids have disabilities and need additional supports that they're not being offered, they need to have access to that money. So this guidance is to say, just because you can take all the money for cost of care doesn't mean that you should. You should be thinking about what the child's long-term needs are and giving them access to money for those purposes as well. So this is, I think, language that is often overlooked. They just focus on the last bullet, which is that maintaining eligibility for public assistance. But you focus on the other parts of the kids need access to the money for other things. The case manager is responsible for planning how this money is to be spent. They're supposed to keep track of the balance and be thinking about those current and long-term needs. And I really like this operating procedure toward the bottom. They're supposed to function as a prudent parent to budget for the day-to-day needs and the future needs. There's a form link there that's an expenditure plan. I think my guess is that this is done in the absence, like mostly not done. We kind of have some freak out moments where they get an alert, there's too much money in the account, go spend it. And they run around and they buy technology or they buy $200 sneakers. And the point is to make a plan and to think about, be thoughtful about what the child needs. So if you're working with a child in any other capacity and they're getting funds in, work with the case manager on what that plan is, work with the child and what their needs and desires are so that there really is a plan, not just willy-nilly spending of money. So the current needs are described in the administrative code provision here that talks about, and you can see how old it is because it includes, money for comfort items like a tape player. That's way, way old. So it's not limited to these items, but these are some of the items that you should be thinking about. How can this kid access their money and what would they be able to use it for? So big advocacy tip, ask to see the plan. If there isn't one, help them make a plan. Make sure that if there's an expenditure plan that is going to, when it hits close to 2,000, that it actually applies because it may not apply to your child. And don't, and really use this as a tool to work with young people. Any quick questions here, Christy?
Yes. If the cost of care is covered by a grant program, does the state still have to be reimbursed?
I don't know what grant programs cover cost of care because cost of care for children and out-of-home care is paid for with Title 4E federal funds and state general revenue. So if we're not talking about kids in out-of-home care, then the master trust doesn't apply at all. So if someone wants to do a clarification, okay.
Okay, and someone else had a question if the minor needs to be legal. I assume that means have legal immigration status.
So I'm not, if the minor has income coming in, it would go into the master trust regardless of their immigration status, if they're a child in out-of-home care. I suppose a minor could not have immigration status, but have a parent that does and get a benefit. I'm just not expert in that. So If money comes in, it would go to master trust regardless of their immigration status.
All right, and one more question. Do guardian ad litems have the right to access information regarding Social Security money? It seems like I was denied that previously as it was confidential.
No, the guardian ad litem is supposed to be provided with the accounting as part of the judicial review and should be able to request it at any time as well. And they should not, an application may be for money, but the money coming into the kid's account and that accounting, guardians ad litem play an important role in making sure it's applied appropriately.
All right, that's it for questions.
Okay, so the next thing the state has to do is to give the kids a process to get their money. So yes, the state can take the cost of care, but they have to issue notice of fee assessment and rights of the child. This is back to con law, taking without due process of law. They cannot take your money without telling you and giving you the opportunity to have access to it. And Florida has codified that in statute and in rule and through its forms. So this form 285D should be provided at every judicial review, and also the application for a review of that fee. So if the request is denied, there's an appeal process. So we actually have due process that will let people get the money. The kid themselves or the GAL or the foster parent or caregiver working with the case manager can make that application. And what you can ask for that is either please take less money to reimburse yourself for cost of care. I get $300 in a death benefit. My foster home is $500. You're taking, 300 minus 15, but please, will you please only take 200 and let $100 accumulate every month? And that can either be a one-time, don't take any money next month so I can have money to go to band camp, or it can be a monthly, please take $100 less so that I can pay for my monthly lessons. So the form kind of walks you through what those options and requests are. And it asks you to provide receipts or details or other documents, the band teacher's announcement of the trip and how much it costs goes to that along with that application. The rules require a committee of 3 people to review the applications, and there's the denial process that gets initiated. To be successful with an application, the application should be clear and specific about what the money is going to be used for, why it's needed, but be creative. There's not a limitation. What is really going to make this child's life better? Put that in there and think about the future. You can start to buy household goods or furniture, or even pay for a storage room as a young person's, reaching that point where if they're going to leave care at 18. So the master trust ends at 18. Florida did not extend it when it extended foster care. So be creative in planning for and asking for that money. You do not have to wait for a judicial review. So if the kid needs something, do the application. And I think the CBCs are much better about it now, but sometimes they get lax and they're not providing the notice. If they don't provide the notice, that's an unconstitutional taking. You can request a refund of that money. It's been several years, but we had kids who got several $1,000s back because of mistakes or failures to notice. So you will be more successful in getting that money back if you can say what it would have been used for if the child had access to it at the time and what it can be used for going forward. So hopefully they're all on top of it and they don't need to do that, but that is possible. What happens at the end? I'm sorry, I don't know what happens if a child dies in care, but when the child leaves care, the law is clear. Florida law says what should happen with the money in the account. If the child turns 18, they are supposed to get their money. Now, the Social Security agency, their regulations say, send us the money back. And so there's a conflict, but Florida law is very clear. And the Social Security Administration did make a policy that says that DCF can ask them in advance for permission to give the child the money. And if they should do that, and they ought to do that. But if you need to get a court order, get a court order, because the law says Florida has to return the money, give the money to the child. It's just a delay. If they end up sending it back to Social Security, the young person can get it eventually, but it could be several months when they really need their money. It also tells them to provide the funds to the parent or caregiver that takes on the responsibility for caring for the child when they leave care. So that's where those funds should be transferred to. So to follow the formal process, I would start at least 4 months before the child turns 18, so that Children's Legal Services can do its process and make sure that the application is submitted to Social Security. But again, Florida law should take precedence. Okay, I'm at the end of mine. I've got 4 minutes to take questions before I'll turn it over to Melissa.
Perfect timing. Okay. Is there an exception to the maximum asset amount related to COVID relief that the children has received this year? Do we need to find ways to spend that money to keep the account under 2,000?
Children should not have gotten COVID relief in their master trust account. And I don't know whether young people under 18 were getting cash from the COVID money. So it is a concern if they have a combination between their master trust and another bank account of more than $2,000, and they get SSI or APD Medicaid, that would be a problem. But it's not one that I've heard as coming up. And I would love to, whoever that is, talk to me afterwards and let's explore that some more.
Okay.
Robin, this is Melissa. I was just going to add something there, if you don't mind.
Sure.
So for people who did receive the stimulus checks, there's actually a longer period of time. I believe it's a year from the time of receipt that you can still have the funds and it not disqualify you as being considered a resource. And maybe Travis can chime in later and just, say if that's correct. But I'm pretty sure it was at least a year that people had to utilize those funds, and it didn't count against them as income for SSI purposes or considered a resource, at least for a year.
Yeah, that's good.
All right, great. One of my children, I'm assuming they're guardian ad litem, their dad passed away. Whose responsibility is it to follow up with any filing to receive possible funds? The child is placed with the grandmother and the mother is missing.
So I would say the case manager, but certainly if I were the GAL or the attorney for the kid, I would be working with the grandmother to make sure that application is made.
Okay. What is the maximum amount a child can have in a master trust account?
So there's not a statutory maximum, but if the child receives a very large payment, a settlement of a lawsuit or a large insurance payout, that money should not go into master trust. And Travis will be talking about special needs trust. That would be a more appropriate tool. So if it's a big chunk of change, it should not go into master trust. It should be in something that's more dedicated and protected and growing for the child.
Okay. Do you have time for one more?
One more.
Okay. In practicality, I do not see DCF requesting court orders for the return of the children. I think they mean the children's funds. Is the court order absolutely required?
The court order is protective of the child. If Children's Legal Services is following the process and they're making an application to Social Security and Social Security is agreeing and the kid's getting the money, then a court order isn't necessary. If that process isn't happening and you want to make sure the money isn't sent back to Social Security, then you would get a court order, but it is not required. So at this point, thank you all, and happy to talk offline, but I do want to turn it over to Melissa so she has her full time.
Yeah. Hey. If we could move to the next slide, Robin, thanks. Thank you. So today I'm going to be talking about ABLE Act accounts, and I'll describe what those are in a little bit, their purpose, who can establish an ABLE Act account, how it is funded, how ABLE accounts can be utilized, and also how do ABLE Act accounts differ from special needs trusts or guardianships. And I just want to mention something before we go on to the next slide that was on the prior presentation. So it's stated there that when the children turn 18, obviously they're entitled to those funds from the master account. And then somebody else asked a question about potentially larger sums of money outside of the SSI money that's going in there or disability. And there is another alternative other than a trust, and I'm not sure if that statute has been amended or the administrative rule has been amended to also allow for ABLE Act accounts. And I think you'll understand why I'm saying that in a few moments. So if we can go to the next slide. Thanks. So what is an ABLE Act account? Well, ABLE Act account stands for Achieving a Better Life Experience, and that was the Act name as well, as you can see here. And it really came about because we were just talking about as well, normally if you're going to qualify for supplemental security income benefits or Medicaid or even a med waiver, or, home community-based service waiver, you can only have assets typically, and there's exceptions to all of these rules, but we're just going to talk about generalizations here today, of $2,000 or less in liquid assets. So one of the caveats of the master account is that the child, like I said, gets the money at the age of 18. So there was something that stated that you have to go into a trust, which Travis is going to talk about special needs trust in a little bit. And that is one tool. But ABLE Act accounts have only been around since 2014. And really in 2015 is when Florida had a statute that was passed that's listed here as well, that set up the program that operates the ABLE program here in Florida, and it's called ABLE United, and they've given you the website there as well. So what is an ABLE? What does that do? It's an account that's established. It's not a trust, so it's an account that's established for an individual living with a disability to really save for their future and not get disqualified from means-based government benefits. So it has, a great reach for individuals here. So if you can move on to the next slide. So ABLE was passed again, and really in recognition of the fact that there's very high cost factors for individuals living with disabilities. And it had been a set rule that if you had more than $2,000 in liquid assets, that you would not be able to then qualify any longer until you spent down that money, and that you couldn't give away your assets of any kind. And you really couldn't save in any vehicle beyond that $2,000 level. So finally, our Congress recognized that this was an issue with a lot of supplemental help from the local communities and that work with people living with disabilities. And they came up with, like I said, the ABLE Act account. So what does it do from the purpose of benefits protection? So for supplemental security income and Medicaid, I've already told you that you can typically only have $2,000 or less in liquid assets. So with the ABLE Act account, you're allowed to keep $100,000, and this is in Florida. It is a little bit different from state to state how they view it, depending upon if SSI and Medicaid are related in that state. But in the state of Florida, up to $100,000 can be in an ABLE Act account and still allow that person to qualify for SSI. And then in Florida, SSI is related to Medicaid, so they automatically get to keep their Medicaid versus having that $2,000 or less in liquid assets. In addition to that, if they reach that $100,000 level, and it will take them a long time to get there, and I'll explain that in a few moments as well, based upon the funding of an ABLE Act account. But if you got to that $100,000 level, then your SSI would be suspended and you have a period of 2 years to bring it below that $100,000. And during that time, you also, even though you are suspended for your SSI, if you go below that, you'll go back on SSI if you bring the number down. And then you also get to keep your Medicaid, because Medicaid has a cap of $418,000 in the state of Florida. And that's also a different number from state to state. So if you are, for whatever reason, working in another state, you need to be able to look up that information. There are also tax advantage accounts. So they grow tax-free, and if they're utilized for certain purposes, which we'll get into a few moments, called qualified disability benefits, basically, then you're not going to have any tax issued as a result of that. If we can go to the next slide. So who can establish an ABLE Act account? Well, an individual, him or herself, can establish it, but you have to look at the person has to be considered disabled and where the onset of disability has occurred prior to the age of 26. It doesn't mean that the person can't be over the age of 26, where you can say that still the onset of the disability began before the age of 26. So this comes into play a lot when you have somebody that's older and you can't really, it's much harder to backdate and retroactively prove that there was an onset of disability unless it's something that's very obvious. But it's much better to have these determinations made earlier on. And hopefully for those of you that are working, most of you are, with children and out-of-home placement in the child welfare system, hopefully we're having these issues raised at the right time so that the child can then benefit even when they're a child and when they're an adult from some of these benefits and from an ABLE Act account potentially. So the onset has to occur again prior to age 26. They are trying to expand that to age 46 through the Age Adjustment Act, but that hasn't been passed as of yet. And that really comes into play with mental health. And I know that there are a large number of children also in out-of-home placement that also have sorry, I was looking at a question that was coming across my screen. That's very distracting. Sorry. I just lost my train of thought there. I'll have to come back to that. A mental health need. So if you can have a diagnosis earlier on also with the mental health need, all the better also, because a lot of times those don't often get diagnosed until a little bit later in life. And I think that's what that Age Adjustment Act is also sort of, covering there. So if a child is receiving or an adult's receiving SSI or Social Security disability, there's an automatic determination that they're considered disabled from the definition of Social Security. But the individual does not have to receive benefits at the time the account's opened if you have a letter of disability certification from a licensed physician, a DO, doctor of optometry, dentist, podiatric medicine, or chiropractor. You'll notice there it doesn't include a licensed psychologist or a therapist or some other individuals who might be involved in that child's life or adult's life. And therefore, you have to make sure that it's one of the above. And basically, the accounts are opened by an individual living with a disability if they have capacity to do so. Obviously, if they're a child, they're not going to. A durable power of agent under a durable power of attorney can do it. Legal guardian, conservator, spouse, parent, sibling, or grandparent, or a representative payee. But there has to be a court order directing that. So recently, Robin asked me to help out in a case where there was an ABLE Act account that was being created because this child was receiving some larger sum of money. I don't even know the reasoning behind it. And there was a circumstance where DCF did not want to open the account because when you open an ABLE Act account, just like any other bank account that you have to open, there's certain information that has to be provided by whoever is going to be opening the account. Some, sort of protected information like a Social Security number. And really that purpose is twofold. It's under the USA Patriot Act. It's a requirement to obviously know who is putting money into a bank and opening an account. But also because if there's going to be a distribution from the ABLE Act account, they need to be able to authenticate that person somehow. So we came up with a unique way of doing it. I'm not sure it was actually utilized because DCF did cave in and say that they were going to set up the account. But in speaking with the head of ABLE United, it was decided and approved that if there was a court order directing an individual, whether it was somebody that the court appointed, whether it was a GAL, that they would accept that as an identifying piece of information for them to be able to open the account. And then they could also restrict the account so that there can't be distributions from the account without a court order, like they do oftentimes in guardianship proceedings. But that way, the person who's setting up the account, if it's not, a parent or a grandparent or somebody that's a representative payee, if it's not DCF for whatever reason, then it can be done via court order. We're also going to look into potentially a legislative fix to that after we're done with this presentation, really. You can only have one account per individual. So this is very different when Travis will talk to you in a little while about special needs trusts. And you'll also see why ABLE Act accounts and special needs trusts can work together. It's very, very easy to establish an ABLE Act account. And if you can go to the next slide, Robin. These accounts can be opened online. So they're all open online, actually, as far as I know today. There's links provided for each state and each state's program. If you go to www.ablenrc, that stands for nationalresourcecenter.org, in all states except for Hawaii, Idaho, North Dakota, South Dakota, and Wisconsin. Some of the programs actually have joined forces, so they operate together and they just are valid in each state. Florida, you can only use it as a Florida resident, so it's just solely focused on Florida residents. States may also vary on the opening deposit amount. I don't foresee you really coming into a need for this unless, like Robin was indicating, if there was an insurance amount that came in where the child was a beneficiary, if there was a lawsuit settlement, or if they were on some type of benefits or the master account was going over a certain level, that it required them to put more money into an ABLE Act account. You also might have someone that is working over the age, let's say they're 16 years old, and they're working in a job. They can also put their money from their job into the ABLE Act account. It still counts against them to a certain extent, usually half after deducting some other amounts against their SSI. For reduction in the SSI, but then they also get to have sort of a retirement savings vehicle for that money, and it's above and beyond what I'll describe as the typical amount that you can deposit into an ABLE Act account. So there are other reasons for using an ABLE Act account, and again, you can use them in conjunction with a special needs trust. The maximum amount that can be deposited annually in the aggregate, so that's from any source that is funding it, is $15,000. Is tied to the annual gift tax exclusion amount. And so right now that's $15,000, but that as that goes up in years to come, if it's still around, it'll be tied to that number. So it's not going to be your end all be all for anything that this child might need or need to have to, again, consider for SSI purposes or Medicaid purposes. Anyone can fund the ABLE Act account, which is a little different. It can be the individual or third-party special needs trust, or a first-party special needs trust can also fund into an ABLE Act account. And when a special needs trust transfers money into an ABLE Act account, it's not considered income. It can also be funded via a guardianship, but you're probably not going to have that circumstance unless the guardianship only has a house in it, because otherwise the guardianship would disqualify the child from the benefits because it's considered their own funds. So it's highly unlikely that you would see that unless it's a smaller guardianship and you're trying to spend down the funds there. Also, if somebody has a 529 plan for purposes of education, those have been around for a long time, you can move over $15,000 from a 529 plan and transfer that into an ABLE Act account. Because what I forgot to say on one of the first slides was that the ABLE Act accounts are also known as 529A accounts. So 529, like I said, was set up for purposes of education only. And 529A plans are the ABLE Act accounts, and they're set up for qualified disability expenses and for people with disabilities. There is no age limitation on how long the ABLE Act account can last either. There's also there is a payback provision in ABLE Act accounts. However, Florida has decided that they will not file a claim against any money that's remaining. But I put here, there's an issue if somebody was over the age of 55 at the time that they passed, because in the state of Florida, everybody over the age of 55, when they pass, have to give notice to Medicaid for any Medicaid estate recovery that there might be. But for purposes of this, that's probably not going to be the case. And Florida will not attach a claim. So what happens with the money when the child dies here? It does go to their estate, and it would go through probate basically. If the child is not of age and they don't have a will at that point in time, then it would go according to the laws of intestacy and be distributed out that way. The other thing to say here is that SSI has Supplemental Security Income, Social Security has a quirky rule when it comes to special needs trusts, and that's if somebody has a first party special needs trust and the child passes away or the beneficiary passes away, there's a payback provision to Medicaid for the state or states that have provided them Medicaid during their lifetime, basically. And so with that fact, you're not allowed to pay for somebody's funeral expenses after the person passes until you know you have enough to pay back that lien interest that Medicaid has. However, with ABLE Act accounts, you can actually use as a qualifying disability expenses, funeral expenses, even after the death of the person through the estate process. So that is allowable. So that's something that, again, coupling things together to get the best that you can for your client or for the child in this instance, and possibly for an ABLE Act account after they turn 18, rather than them getting the money at age 18, or rather than it having to go into a trust specifically, you can also utilize the ABLE Act account. There's also Able to Work Act that was passed, I believe in a couple of years ago. I don't remember the exact year, but that's where I was saying that on top of the $15,000 a year, if the individual is working, and it can be a minor working as well, they can also put in an additional $12,760 a year into the ABLE Act account to be utilized for their qualifying disability expenses. That number changes every year and is tied to the poverty level. So I'm going to take questions at the end. So I'm going to ask one of my other presenters if they can tell me when I'm getting close to that 5-minute mark, and I'm be happy to take questions if you don't mind. Thank you.
Sure, you're at 7 minutes.
Move on to the next slide, Robin. Okay, thank you. So how can ABLE Act accounts be utilized? They're utilized for qualified disability expenses, which really is anything to keep to help that person with any expense related to their needs. Also to keep them as independent as possible. That's the other part of this, because we have many people living with disabilities that can handle their own accounts. It doesn't mean that they can't. So we want to make sure to, again, provide the supports and independence to them that they're entitled to. But it can be used for food, housing, education, transportation, medical needs, really general health and well-being, assistive technology, anything that you could possibly think of that would help them with their needs. There are a few different things, and I've cited you to the POMS here, also the Programs Operations Manual system that takes the regulations and gives more of a plain meaning and how care managers look at things from that standpoint. And I just mentioned here, food and housing are in-kind support and maintenance. And a lot of times, if you pay for in-kind support and maintenance from another source, even if it's being paid directly to that source, like directly for somebody's rent, perhaps, or for their food or shelter costs, there can be a reduction typically of 1/3 plus $20 from the full federal benefit rate amount. So it will reduce their benefit from $794 from SSI to $510 a month, basically. So you can use an ABLE Act account where it would not cause that reduction and against them. So they get to actually keep more money. So they get to keep the full $794 potentially. So I think that's important to mention. If we can go on to the last slide.
Yep, and you're at the 5-minute mark.
Okay, I'm going to go through this just really quickly, and then I'll leave room for question and answers. And I think we might have some time at the end as well. So again, what is the difference between an ABLE Act account, a guardianship, or a special needs trust? Guardianship does not protect you from means-based government benefits eligibility. ABLE and special needs trusts do. And again, Travis will be talking about that more. The ABLE Act account has limitations on funding where a special needs trust does not. ABLE is more flexible sometimes than an S&T. You can have more than one S&T, but only one ABLE Act account. And ABLE and S&T are not mutually exclusive. And I know that Travis Finchum is going to be taking off from there and explain what that means a little bit further. So now I can take some questions.
All right, thank you for all that great information. We had some good questions coming in. Can a child have both a master trust and an ABLE account, or do all assets have to be put in the ABLE account once it's established?
I would say that they can have both a master account and an ABLE Act account, because the ABLE Act account isn't really there for the SSI money until it becomes a resource if you were to go over, a certain cap. So you can have both.
All right, great. Is ABLE a savings vehicle that children are eligible for?
Yes.
That's easy. Can the cost of care be charged from the ABLE account?
I would defer that one over to Robin. I don't believe so. I don't believe it should be. I guess it could be, but I think it should be coming from the master account because that's what that money is there for, right, Robin? Or
Yeah, the state wouldn't have access to that money. They can only do it from the master trust account.
Okay, that's what I thought.
What language would need to be included in a court order that would allow for a CBC to open an ABLE account on a child's behalf?
I think that would be what you just described. The court would direct that the CBC was entitled to open the ABLE Act account. They might need to designate a person, as long as the CBC has a representative that's willing to provide the information that would need to be provided. And then I would also either have that restricted or have the court order what could be paid from the ABLE Act account, especially since it's a minor situation, it's not in a guardianship. Typically you would have money if it's over $15,000 in a guardianship account. So I think that you can get around that within that court order, but the court might decide they want to restrict it and only allow for some budgeted items to be able to be requested. And you might have to do an accounting. I'm sure you'd have to do an accounting to the court for that as well. But the one difference is the money doesn't get turned over to the child at the age of 18. So it's separate and apart from really DCF or, anybody having control over it.
Okay. If a 38-year-old is approved for SSDI and was in special education with a low IQ prior to age 26, but didn't get benefits until recently, would an ABLE account be appropriate? The client will get a large SSDI retroactive benefit, and there's concern about her ability to manage the funds.
Wow, that's a loaded question. First of all, Social Security disability is a non-means-based benefit, so you don't need to have it in a vehicle that's going to protect that. But I will say that based upon the description that you gave me of the individual, that there may be a need for other types of Medicaid services, such as Medicaid waiver services, or potentially, even though there might be a larger amount from disability, there's going to potentially might have the use of the qualified Medicare beneficiary benefit that kind of acts as a supplement to the Medicare. So I never look at things just as what that person's receiving today. So I would still have that discussion. There may be other vehicles to use that might be better than an ABLE Act account, but that's one thing. And I don't remember the third part of that question. Can you repeat that?
Yes, so there was concern about her being able to manage the large SSDI retroactive lump sum.
Yeah, so she should have, okay, so there's a retroactive amount. The retroactive amount is not going to disqualify her once again, unless she needs some other type of Medicaid benefit, then it could disqualify her. So I think that I mean, you can have a different person be the rep payee for the Social Security disability if you want to, but if you're really concerned, I think there needs to be an assessment done to see if a guardian over the property or a guardian advocate, or if less restrictive alternative, she can name somebody as a agent under a power of attorney instead for her to help her with that process. And then they can manage it for her.
All right, Robin, do you want to save the other
I
questions
think
for
I'm
the
cut
end?
off.
Yeah, we'll have some time at the end, but don't want to cut Travis short on his time with us.
Perfect. Thank you so much, Melissa.
Okay, we'll go ahead and get right into it. Hang on a second, it's gonna take this a second to launch, of course, and then I gotta switch it around here. Always does that. Well, thank you. I'm Travis Finchum, and wow, those were two great presentations. Thank you, both Robin and Melissa. And Melissa, you were setting me up with softballs. Thank you. Those were nice lead-ins to what we're doing, and this all does kind of tie together as Robin's talking about the master trust and how it functions. I'm sitting there going, that's a pooled trust, basically, is what it is. And we'll talk a little bit about that. But this is my firm. This is me, Travis Finchum. I'm in Clearwater, where there's apparently an ambulance going down and a thunderstorm about to hit. So we'll see if this all works out. So just some general things about special needs trusts. And this is also, and Melissa talked about this with the ABLE accounts. The individual has to be disabled. And that's a big issue that I get sometimes in the special needs trust world. I get calls pretty frequently from either an ad litem or someone who's working with an individual who's aging out and is about to get some money in the master trust. And they're saying, this person's not going to really be able to manage it or handle it. Can we set up a special needs trust? And the question I have to ask is, are they disabled? Do they have a diagnosis? Do they have a condition where Social Security would probably agree that they meet the definition of disability? And sometimes that's not the case. In fact, a lot of times it's not the case, right? So two things to keep in mind with the ABLE account and special needs trust is that technically the person should meet the definition of being disabled. Does it mean they have to be on benefits? Not necessarily, but we can't just be setting up special needs trusts for people who aren't disabled and don't meet the criteria. And that's also one of the big differences, and Melissa was kind of talking about it, and I think maybe one of the questions talked a little bit more about it, but another clarification is the ABLE account is the beneficiary's funds. It's theirs. If they're a minor, okay, they can't manage it. A parent can set it up and be in charge. But as soon as that person turns 18, it's their money. And they can basically do what they please with it unless they have a legal representative like a guardian. And Melissa mentioned that, a guardianship or guardian advocate for that person if you're looking. But if you just set up an ABLE account for someone and they're an adult and they have all their rights, they have control of those funds. There's no safeguards there. One of the differences with a special needs trust, there will always be a trustee in charge of it. And pretty much never are you going to have the beneficiary be the trustee of their own special needs trust. If they are, it doesn't work for most of the purposes. Of course, the purposes are we're benefiting the individual, but the big one here in the middle is that we're trying to maintain that eligibility. And again, Robin did a great job of talking a little bit about, there's checks from Social Security, and Melissa mentioned it too, that don't have any financial eligibility criteria. You can be wealthy and still be getting a dependence check or getting a disability check or a retirement check. But for these purposes, most of the individuals were looking to maintain that SSI or a Medicaid or Medicaid waiver, and we're looking to use these funds to pay for additional things on their behalf that's not being covered. And so sometimes the special needs trust might be the place to accumulate things. And the part about Robin talking about one of the rationales for charging the minor for their services is so they don't accumulate it. Well, I think that argument is a pretty weak one because we now have two options for many of those individuals. We've always had the special needs trust if they meet, if they're disabled and they meet the criteria. And now you have ABLE accounts. So technically we don't have to be charging them if the reason is we're worried about them accumulating, because they can accumulate $15,000 a year in the able, and there's no limit as to what you can contribute at any one time or over your lifetime to a special needs trust. I'm not going to talk about these in any real detail, other than from the public assistance programs. The main one we're dealing with for special needs trusts is SSI. The dependents benefits, the disabled adult child, those benefits don't have limitations, but oftentimes you'll have an individual who's eligible for multiple programs. And so they may be getting a Social Security disability check, SSDI, and they may be getting the Medicare that's tied with that, but they also may be eligible for Medicaid as a supplement. And you probably know, and I think I've got the chart up here in just a little bit, that for those of you that do any applications or advising people in dealing with the Medicaid programs, that there's a lot of different kinds of programs. And I'm going to hit a few of them that are typical that we're looking for people with special needs trusts. But the Medicaid and Medicaid waiver programs are our main goals. So those are the ones we're looking to maintain. And so for the SSI and Medicaid, you've got your medical necessity, you've got transfer penalties if a person is trying to either apply for or maintain eligibility for one of those programs. And if you give away funds, they're going to penalize you, because there are resource limits. $2,000 is the typical one. There's some other programs have a little different levels of both income and assets. And the other thing to keep in mind is that, as a general rule, a trust that has a beneficiary who's eligible for one of these programs is going to count unless it falls into one of the exceptions. And the special needs trusts that we're going to talk about, specifically the D4A and the D4C trusts, those have very specific requirements to qualify for them, who can set them up, and those are specifically set aside as exceptions to the rule that you can't take some money that you have, put it into a trust, and then immediately say, now I'm broke. I don't, this money doesn't count anymore. And so there is, we have to understand these exceptions. The chart that I was referring to is this one. They changed it. I don't know if those of you guys realize that they changed it. I think the July one. The ones earlier were a lot easier to read and understand. But for these, you've got your long-term care and your waiver programs up here at the top that has the income limits and the asset limits of the $2,000. But we shouldn't lose sight of that for some of those beneficiaries that are getting a DAC benefit, maybe on a parent's work history, or if they've worked some in their lifetime to get enough disability on their own. That's probably not going to be most of what you all are dealing with. But there are people who get Medicare may also qualify for one of these programs that help cover some of the Medicare premiums, like QMB and the specified low income Medicare beneficiary, the SLMB. So those have a little bit higher income limits than the SSI figure, and they have a little higher asset limit. But the idea is any of these programs that have an asset limit, and these are the Medicaid programs in Florida that are related to SSI, as opposed to the Medicaid programs in Florida that are for families, which the Medicaid programs have no asset limits to them. They're income based only. So what we're looking for is, when you have a minor child and family related Medicaid, totally different set of criteria can apply there, and special needs trusts may or may not help. This is for an adult who is now getting into a program that has a means test to it, and we're looking to shelter some of that money. Just for a little bit of background, you should know that there are a couple of different kinds or categories of special needs trusts, and I kind of just break them out into two. There's the self-settled trusts, and those are the trusts where it's the beneficiary's money that's going in. And we'll talk about why a beneficiary may have accumulated this money and need to do it. And I'm not really going to talk much about the third-party trusts. You may see those, probably not for this population, because that's when another family member has set up a trust. A parent, a grandparent, aunt, uncle, or somebody has set aside some money in a trust, and the rules for that are very different, and those are called third-party trusts. We do a lot of those for estate planning for our families that are intact and are looking to protect a vulnerable family member. And for trusts So we just kind of have the lingo. You've got the settlor, or the one who's establishing the trust. You've got the trustee, which is the manager of the trust, and you've got the beneficiary. And so in each of these cases, who the settlor is, who the trustee is important to determine how the trust is going to be treated. The only slide I'll mention about the third party is, again, that's another family member sets it up. You can do it in your will, you can do it inside of a trust. And this kind of a trust, and Melissa mentioned a little bit about this before when she mentioned special needs trusts, that some have a Medicaid payback to them. Third-party trusts do not. So they would normally have other family members or other beneficiaries that are designated. The self-settled trusts are the ones we're mostly going to talk about, because this is when it's the money of the individual. Well, why would a minor who's aging out of foster care, have money? Well, maybe somebody dies and leaves them an inheritance, somebody they didn't know about or didn't plan for. Maybe they're injured, and that happens too. It happens sometimes in care, and there's a lawsuit that results in the recovery of money. And now what are we going to do with that? And then the bottom one here is the master trust example. They've accumulated money, and they've either saved their Social Security checks, or if they worked and made a little bit of money. So now they've got some funds that is going to go to them, because we just learned it's got to go at age 18. So all of a sudden they're going to come into this money. And if we want to maintain those benefits, we've got a problem. So there are really 3 primary special needs trusts, and only 2 of them are applicable for money coming out of a master trust. It's the D4A and the D4C. And this is the section in the federal law where these trusts exist. They're in the 42 United States Code, which is the Social Security Act, because a lot of these benefits are based upon Social Security types of benefits like SSI and Medicaid. And so the D4A is the individual trust. You may see some of those, but those are a little more challenging, especially with smaller amounts of money. By that, what I mean is, if you're having to go establish your own trust, because that's really what a D4A is. It's you're setting up your own trust, picking your own trustee, going to have your own money management, and the beneficiary can't be their own trustee. So maybe we've got a professional, a bank, or a trust company. And if there's not a significant amount of money there, it's not going to work. Those would probably, for our population here, are going to be the large personal injury cases, or maybe a large inheritance. That would be wonderful if that happened. But usually there's not a hard and fast number. I typically am in the $200,000 to $300,000 range, because if it's smaller than that, it's very difficult to find a trustee to manage it, to invest it, and to be able to do it cost effectively. The pooled trust is more likely going to be the better alternative. Mentioning just real quick, the middle trust there is our qualified income trust. So it's all in the same section of the federal law that was passed in 1993. The qualified income trust, though, only works to help people qualify for either the nursing home Medicaid program or one of the Medicaid waiver programs that are based upon that. That would be the APD program. And that would just be if your monthly income exceeds the maximum monthly limit, which is, I think, $2,382 for this month, or for this year, per month. And that's going to go up. But that's if your income is over. Not going to happen very often. That's more so our elderly population, where somebody's in a nursing home and has Social Security and a pension and other things, and their income is over. So the pooled trust is more likely the one that's going to make the most sense. And like I said before, this is basically a master trust. It's just a little different variation of it. I would mention that all 3 of these trusts are subject to a Medicaid payback provision when the individual passes away. So that's one of the concerns we just need to know about. And that age limit of 55 doesn't apply in the trust recovery world. That's only over in the probate world, in the probate and estate world. And so the pooled trust is going to be probably the option for our smaller accounts. And so basically what we mean here is by, just like with the master account, by having one trust document, but having sub accounts within it, helps keep the costs of administration down. You only still have one trustee and one beneficiary, one trustee, one money manager, one person who's basically, in charge of the whole thing. And it keeps the cost down by doing that. Some have very low fees, as low as $500 or less to set up. And most of them do not have a minimum monthly fee or annual fees and things like that. Not-for-profit organizations are who's going to set up these trusts and run them. And so again, sometimes they can do it less expensive than some of the others. So the advantages of a special needs trust is, again, we're going to maintain government benefits. We're going to be able to keep the money, and we're going to supplement the individual's needs as they may arise. Some of the disadvantages are you can have some limitations on the use of the funds. We didn't talk a lot about that, but Melissa alluded to one of the aspects. That would be if you spend the money in one of these trusts for an individual who's on SSI, if you spend the funds on their food or their shelter expenses, they're going to reduce their SSI benefit. So there can be a challenge there. If the individual does have an ABLE account and we move the money from the special needs trust into the ABLE account and then pay for the same exact expense, there's no reduction in their Medicaid or their SSI benefits in the SSI. And so it's a way to help cover some of those expenses with the same funds. You just have to flow it through the ABLE account. And so therefore, again, the individual has to qualify for the ABLE account. We mentioned it can be a challenge with selecting trustees. So sometimes that's, again, where the pooled trust can be helpful. And then the assets are subject to the Medicaid lien or the payback provisions to them. A couple of things, I left a few of these in here just to talk about. You're not going to maybe see family law, but sometimes if there's support payments that are being made and we have a beneficiary who's on SSI and sometimes Medicaid, it can affect their SSI check if they're getting a support payment. If that support payment is directed into a special needs trust, we can actually have it excluded and it does not affect their SSI check. And so there's a specific provision in the POMS that talks about having both alimony or spousal support and child support assigned to a special needs trust in order to have it protected and exempted for eligibility purposes for SSI. We talked a little bit about the personal injury case. What I also sometimes find in settling some of these PI cases when there's a minor involved, the PI lawyers like to get the money directed right into a special needs trust to possibly avoid an ongoing guardianship. And I know Melissa alluded a little bit to that if the court's involved and there's a guardianship and there are funds within the guardianship, well, those count usually toward eligibility for SSI and Medicaid. And unless the asset is a house or another exempt asset, it's going to cause a problem. So even in that case, we still maybe want to get the court to authorize the funds to be moved over into a special needs trust. And if you just skip that in between step and say, well, in lieu of establishing a guardianship to just transfer them right into this special needs trust, can we just have it go right into the trust with a professional trustee handling it? A lot of times the civil court judges will allow that to happen and not have to open up a guardianship to just close it out. So the last slide that I have, and then we'll have a little bit of time for some questions. And then I know we had 5 minutes overall for questions as well. Is this chart, and I know it may be a little difficult to see, but I'll make sure that this chart is available for everyone, and I'll have my materials on my firm's website as well, which is specialneedslawyers.com, but I'm sure you'll be able to get them through this program. But what I have done, and I continue to work on, this is not designed to be a Christmas, even though Christmas is right around the corner, This is not a Christmas slide where it's red and green. It's more of a stoplight sign where it's green is go, red is stop, and orange is you better either hit the brakes or you better punch it if you're going to get through, because it's a maybe or maybe not. And what I've done is I've got a little comparison of the ABLE account that Melissa was talking about, the individual D4A account we were talking about, D4C pooled trust, and then a third-party special needs trust. Again, I'm not going to talk a whole lot about the special needs trust, the third-party ones, because the different funds, family members setting it up, things like that. But one question, and green is supposed to be good, is a good answer. No, it's not necessarily. Like, can it be established by the beneficiary directly? Well, beneficiary can set up their own individual trust or ABLE. And of course, they can't set up a third-party trust because it's third-party money. Limited annual contributions. Well, ABLE account does. Melissa told you about that. It's $15,000 a year. And then if you do have some earnings, you can put a little extra. There is no limited contributions for any of the special needs trusts. We talked a little bit about the Medicaid payback provision. Definitely Medicaid paybacks in the self-settled special needs trusts. I've got that orange there because it's assortive, right? Like Melissa said, 55 years of age is the issue. If the person is over 55 and has received Medicaid benefits and has an ABLE account, then those funds in the ABLE account could be subject to that Medicaid estate recovery lien. If they die before 55, it's not a problem. If for any services they received prior to age 55, there's no recovery for that. It's only services after 55 and after they die. Can you pay for food and shelter for SSI recipients without affecting benefits? We talked about that. The legal money laundering of putting in money from a special needs trust into an ABLE account allows us to pay for food and shelter without impacting benefits. ABLE accounts can grow tax-free. I don't know if Melissa mentioned that, I don't recall, but 529 plans grow tax-free. 529A plans grow tax-free. And so special needs trusts do not. There are lifetime maximum limits for ABLE accounts. If it gets to $100,000, the excess starts counting toward SSI. For special needs trusts, it does not. ABLE accounts are very specifically exempted from creditors in Florida. Special needs trusts, if it's established with the beneficiary's money, generally is not. It's their money. You can't set up your own creditor protected special needs trust in Florida. Third-party trusts are. Melissa mentioned that you can pay for funeral after the death of a beneficiary out of an ABLE account. You can't do that out of the self-settled trusts. Low fees, ABLE accounts are very low fees. In fact, I think the state has waived their annual fees. The only fees you pay right now are for the money management fees. D4As are going to be more expensive. Pooled trusts are going to be less expensive because, again, pooling the funds is a lot more cost effective. The ABLE account has a little bit broader distribution standards. You can pay for more things probably out of an ABLE account and when than you can for the self-settled special needs trusts. And then this last one is the one I mentioned before, and I've got it as green, but it could be as red gets if the beneficiary isn't capable of managing it. I mentioned this before, can be controlled by the beneficiary directly. Well, these other trusts cannot. And that's maybe a good thing. Maybe I should flip these around and those should be green and this one should be red because the beneficiary directly sometimes isn't able to handle and manage the funds. And that can be a scary thing. But for a beneficiary who is capable, an ABLE account is a great way to give them some independence and give them some control of some money that they wouldn't be able to get in a lot of other situations. So with that, I'm gonna end and see, I don't know if there were specific questions for me or if we want to just go right into some of the leftover questions as well.
Great information. We got some compliments on your red and green chart already.
It's that time of year. It's getting there, isn't it?
And everyone had such excellent timing and we still have a few minutes left for questions. So first one is, Travis, you mentioned moving to ABLE accounts and then paying housing and other expenses. Have you done that in the same month housing is owed as opposed to transferring ABLE in a prior month and paying in the subsequent month?
We do this a lot. I mean, literally hundreds of times a year because we fund a lot of ABLE accounts with our pooled trusts and the trust that we administer. As far as the timing goes on when it goes in and out, I don't always know because we don't control the ABLE accounts, but I don't see any reason at all why the funds couldn't go right in and go right back out. Contribution to an ABLE account is not income to the beneficiary or the owner. And there's no time period. It has to be in there before it's legally laundered for that purpose.
Okay. All right, here's another
Can I add one
compliment
thing
about
to
your
that,
chart. Yep, go ahead.
Can I add one thing to that response? But if it's housing, just to make sure it's clear, you do have to pay in the same month of that receipt. You can't let it go into the next month for housing or it will be considered a resource. Right, Travis? He's on
Well,
mute probably already.
No, no, that's only an
housing
issue
only.
once you pull it out of the ABLE account and you're going to pay it. You've got to
That's
do
what
that.
I meant.
Yeah, the contribution
what
to
I
the
meant.
ABLE account, there's
That's
no
what I
time
meant.
period. Yeah. Yeah, once you
No,
pull it
no,
out, and
I was
really you
talking about
shouldn't be,
distribution.
yeah, you really shouldn't probably be pulling it into your personal account and then paying it, though you could. You can just pay it directly out of the ABLE account. Nowadays, Florida ABLE has, I think, a debit card you can use. If you can, you might have to pay rent with a debit card. But yeah, I don't think it has to be paid in the same month it goes into the ABLE account. But if you pull it into your personal account, you're right. You have to be careful because it starts counting in your own funds once you pull it out of the ABLE account if you don't spend it.
All right, next one has a compliment and a question. Really like your red, green, and orange chart, Travis. Are you aware of a specific example of Medicaid seeking payback for ABLE subsequent to Florida stating they wouldn't pursue it?
I am not aware, and it's funny because when ABLE's been around, I think what now 6 years, and I kept asking John Finch, who was the director of ABLE United. I kept asking him for years. I go, have you had anybody die yet? What are you going to do when they die? And his answer was no. And I don't really know what we're going to do. But now they have adopted this formal thing where it says it goes to the estate and they're not going to file. They can't, if they let it go into the estate, they can't file a claim if the person is under the age of 55. So I do know that people have died. He told me that, and he told me what they did. I wasn't involved with the case or the matter, but to my knowledge, Medicaid was not paid back in those instances. ABLE's never going to get paid back, the ABLE program. It's just whether your Medicaid has to be paid back.
Okay. Does substance abuse dependency constitute a disability for the purposes of ABLE accounts or special needs trusts?
You want to take that, Melissa? Or do you want me to give it a shot? That's not an easy one. I'll go.
I'm sorry. Go ahead and take it, Travis.
That's okay. I'll go ahead. Substance abuse by itself is not a disability. That's an automatic disability determination. And those can be really challenging cases. I don't do Social Security disability claims, but in talking to attorneys that I know that do that, they can be very challenging because you have to show that you have a medically identifiable condition that prevents you from being able to work and make a certain amount of money. And so I think you're going to have other things aside. You may have mental health issues that you can point to. You may have other things, but just strictly having a substance abuse problem is not a medical condition that Social Security recognizes preventing you from being able to work.
Okay.
That's to my knowledge, yeah.
All right. Does autism without intellectual impairment qualify for disability?
Again, back to me, I don't do Social Security disability claims, but my short answer is autism is not an automatic disability like ALS and certain diagnoses. Schizophrenia is. Bipolar is not. So there are certain diagnoses that automatically open your door to disability. And to my knowledge, autism does not. So you're going to have to add in other things, functional and limitations that prevent the person from being able to do. And there may be more people who know more about that than me. And I see Robin coming up.
I was just going to add, there's a difference between the definition of disability for children and for adults. And so much more likely to get an autism as a basis for disability for a child without any additional intellectual impairment than for an adult, but it is also not my area of expertise. So it's not a rule out, but it's not an automatic rule in either.
Okay, maybe we have time for one more. Are fees associated with establishing a guardian advocacy approved expenses for ABLE accounts?
Yes.
All right, that's easy.
Yes.
Sorry, Melissa. I saw you were on mute, so I went ahead.
Both answered that one. I wasn't quick enough to get my mute off. Mute button off.
Do you want to take one more, Robin? We got one more left.
Sure.
Okay, so if a
Especially since
guardian,
it's not for me.
is it? If a guardian was awarded up to a 5-year temporary guardianship, can they set up an ABLE account, particularly a few months prior to the 5-year mark? It's a challenging one for the end.
Letting you go, Melissa.
Can you repeat that? Sorry.
Yes, if a guardian was
Repeat that.
awarded up to a 5-year temporary guardianship, can they set up an ABLE account a few months before the 5-year mark?
Well, if they're setting it up as guardian for the individual, and then the guardianship I've never seen that really happen. Are you talking about an adult or a child, or I don't understand the situation, but if it's for anybody, and let's say they're being restored to their capacity, I don't understand why it would be a limitation of 5 years. Then it's that person's own funds at that point in time, and they can do whatever they want. They can close out the blocked account. And I'm assuming they'd have to have court permission to open one up as a guardian, because normally you have to get the court's permission to do so.
All right, well, thanks for answering all those questions, everyone. Lots of great information today. Thank you all for hanging in there for the whole hour and a half and a few minutes over. I don't want to forget to announce the CLE credit for the attorneys on our webinar. It's 2108663N as in Nancy. Again, that's 2108663N as in Nancy. I'll send that out tomorrow along with the recording and the PowerPoints and anything else that I promised to have our presenters answer in a follow-up email. So thank you all so much. Go ahead, Robin.
I'm just going to add one thing. There was a question about whether our presenters work with elderly population, and both Travis and Melissa do. They are experts, not just in juvenile. So you will have their contact information, pick their brains. Thanks, everybody.
Thank you all. Have a good afternoon. Bye-bye.
You too.